We're very fortunate to have on our panel today two of the smartest lawyers in the business. Evan Kraus is a partner at Gray, Kraus, Stratford, Sandler, DeRochers, LLP. He's a devoted entertainment, I like that word, devoted, a devoted entertainment lawyer with extensive experience in music, film, television, and multimedia projects. He represents clients across a wide array of musical genres, negotiating agreements with major record and publishing companies, as well as recording, licensing, agency, touring, and management contracts. Evan handles all aspects of film and television production, including financing, story rights, talent, and distribution agreements. And we're joined via Skype by Steve Winogradsky, a partner in the firm of Winogradsky Sobel. With over 25 years' experience as an attorney in the music industry, Steve provides music business affairs and legal support for composers, songwriters, music publishers, recording artists, and television, film, video, and multimedia producers. He's also the author of the recent book, Music Publishing, the complete guide available in hard copy or as an ebook, and Evan actually has a copy here. It's a fantastic book. If you really need to know what's going on in the music business, I recommend you pick it up. So Evan and Steve, welcome and thank you for joining us today. Evan, why don't we start with you first and talk about a typical work-for-hire film agreement. First of all, what does work-for-hire mean, and what are the implications for the composer who works under a work-for-hire agreement?
Sure. Well, work-for-hire is a creature of the U.S. Copyright Act. It's a defined term within the United States Copyright Act. Essentially, it allows what we call a corporate author to own a copyrighted work. In the case of our panel today, we're talking for the most part about a musical score or compositions. Obviously, it could apply to any type of copyrighted work, or many types of copyrighted work. Obviously, there's dispute as to whether it can apply to sound recordings, but it can apply to a screenplay, for example, choreography work, sculptural work. So in our case, it would take the form of a corporation hiring a composer on a work-for-hire basis, such that the corporation becomes the owner, and actually it's deemed the author, which is an interesting concept as well. From inception. Yeah,
it's interesting that this kind of predates this whole thing about corporations being people, but so the idea that the corporation is now the author and automatically is imbued with all the same rights that an individual person author would have.
So yeah, once the employer for hire becomes the author from inception, they vest to all of the rights provided in the Copyright Act: the right to reproduce the work in copies, the right to distribute it, the right to create derivative works, all exclusively and to the exclusion of the personal author, the individual composer who originally created the work.
So Steve, the original composer for a film score really ends up with no rights except the rights that a work-for-hire agreement grants back to him. Is that right?
That's correct. Typically, the work-for-hire agreements will have some kind of provision allowing for writers to collect certain types of royalties that might come in. In a typical publishing situation, the writer would share basically 50% of any performing rights that would be paid directly from their performing rights organization, 50% of mechanical licenses if there's a soundtrack album, 50% of synchronization licenses if there is a license from the production company to a third party. The key to remember, though, is that nowhere in the Copyright Act are the words writer's share ever mentioned. Mm-hmm. This is done by custom and practice, but more importantly, there should be a clause in the contract that allows for the writer to collect these royalties either directly from their PRO in the case of performance royalties, or to have the production company / publisher pay the other types of royalties as money accumulates.
So does every Hollywood composer get the same agreement? Or what are the variables in a work-for-hire agreement? What kind of things can be negotiated? Steve, I'll turn to you.
Well, typically, interestingly enough, the larger production companies tend to have the more liberal agreements in terms of what rights the writer actually has. In small production company agreements, it will sometimes say that the writer can get the performing rights and is silent regarding any other type of right, because the smaller companies don't have the infrastructure to act as a publishing company. The major companies do, and they will usually include things like 50% of sync rights, 50% of mechanical rights. Typically, there's producer and artist royalties for a soundtrack. And the smaller production companies don't have that. But this is all spelled out in the agreement, and so it's important to make sure that the writer is protected by having the correct language in the agreement.
So is the writer just out of luck with those smaller companies? I mean, what happens if there are mechanical royalties that come in with a small company? Is the writer just, he's out of luck? He won't get his share of those royalties? Is that right?
He won't get a share unless he's negotiated for it up front. As I said, for small companies and writers of lesser stature, not creatively, but from a industry perspective, they don't have the negotiating leverage to try to insist upon this.
Do you want to comment on that?
Sure. Well, I agree with everything Steve said. It might be good to also take a sidestep to talk about the difference between film and television.
Good.
Because you will see a different approach to some extent between an entity that hires you for composing in television versus film. My experience is that television is much more restrictive in how they approach it generally, and we can delve into that. And film producers tend to be a little bit more creative and liberal.
Is that because television produces? I mean, it's only fairly recently, and at least from my standpoint, it's only been fairly recently that networks have gotten into the music publishing business. And film studios, of course, have always had realized the value of music. For television, I think this is relatively new territory, isn't it?
I couldn't tell you the history of it. I just
I'm
know
older
that,
than you. That's why I know this
I just
stuff.
know that, when you're dealing with a television network, it's a whole nother game. For example, just by one example, Steve was going through some of the royalties that you will contract for. Obviously, the writer's share of performance income, as Steve said, synchronization income, if there's a third-party synchronization license, meaning, and it's worth noting because sometimes composers ask, do they get paid again somehow when they see their music in the exact same television program or film that they composed for? And the answer is no. Your composer fee or your creative fee is part and parcel of those synchronization rights. But as Steve was alluding to, you want to negotiate for example, if the hiring entity, the film, the network or the film producer, if one day they license the music, let's say, for a car commercial, which as many of us know can be very lucrative. I mean, it's not uncommon to see a U.S. 6-month television campaign fetch at least $100,000 per side, $50,000 per side, meaning for the master and the publishing. And of course, the network will own both your master and your publishing. So it would be great if your client is receiving a piece of that synchronization fee for third-party synchronization uses. But to the point of the difference between a television agreement and a film agreement, just one example that I've come across repeatedly is Steve alluded to the master royalties for the artist and producer. I've found that with television companies, they don't like to allow the composer, in this case we're referring to them in their producing and artist capacity, to receive a master royalty, which is problematic. So it means they'll receive a mechanical royalty, as Steve said, if the publisher decides to reproduce the songs on records, separate and apart from the program. Maybe it's a hit song, and they, if it's a children's program, all the kids like it and they download it, you will hopefully get your mechanical royalties if you negotiate for that. But what about the master side? And you'll find that they don't like to give master royalties.
Yeah, interesting. Do you find that also, Steve, with your television deals?
What I have found is, although they may not be ready to address it, most companies will allow for a good faith negotiation clause in the event some kind of exploitation happens of the master. So they may not negotiate what the royalty is going to be, but they will put in a clause saying, if this happens, we will negotiate. I've had that happen sometimes with my television composers, where a soundtrack album for the program is done, and it's mostly songs that have been licensed into the show, but usually at least the theme song and maybe one or two underscore pieces are included on the soundtrack album, and the client will get producer-artist royalties as if it were a master.
So let me ask you about, does a typical film agreement, Evan talked about, the corporate author. Is there then a restriction on what they can do with the music? In other words, suppose they want to use this for another movie. I say, gee, that piece of background music for that bar scene worked great in movie A. Let's put it in movie B. Is there a restriction on what they can do with the music beyond the original production?
In most major studio contracts, the answer would be no. Sometimes for small independent films, which are almost a different business model, which I know we're going to discuss, sometimes it can be restricted in that way. But typically, the production company, as copyright owner, has the ability to do anything with that music that they want to.
And what about unused tracks? I mean, you get a job, you're supposed to, and you write this great track, and the director says, "Nah, I don't like that. Do something else." What about all that music? Is that covered by the agreement? Is it not covered by the agreement? Whose music is it?
Well, typically anything that's written for the film would be owned for the production company. It's possible to negotiate a reversion of those rights to the author if the film company doesn't use it, but that is kind of unusual that happens.
Really?
Usually the second version, third version is a variation on the first version.
Okay.
I'm happy to report that in a recent negotiation with a major network for children's music, which is in this case not underscore but specific songs, I did successfully negotiate for my composer clients, they happen to be lyricists, but that's not relevant, to have a full reversion of exactly what you say, unused songs. And in this case, it's perhaps a creature of the way the deal was structured. It's like a step deal. So first, they want the composers to go in and meet with the executive producer, see the script, and then come back after they get some direction and submit demos. So they'll know early on whether their music is going to be used or not. And as you say, it would be a shame, although the network, may reject it, the composer may feel passionately about the lyrics or music they've written. It would be a shame to have it, shelved forever.
Well, yeah, and that was part of my question, is because I think, these days there's life for music beyond, there's a lot of opportunities for composers to be able to use music that maybe wasn't used in the original film, and I just wonder whether...
Where I have seen situations where the music will revert is if a composer does music for a pilot, the pilot doesn't get picked up.
Okay.
And so they will get a demo fee for the pilot score, and then if the pilot gets picked up, they will get a second fee to complete the score. But if the pilot doesn't get picked up, typically the music will revert back to the composer.
Have you ever had a situation in which a studio went after a composer because he used a theme that he used in their movie, and he decided he loved that theme, he used it for another movie or another project? Has that ever happened? I mean, as the copyright owner, they would be the one to sue, right? So studio would come out and say, no.
I can't speak for Evan's company, but in my office, we call those people defendants.
Okay. All right. So, but the studios do enforce, they enforce their rights in that area.
Absolutely, as any copyright owner has the right to do, and typically does. I mean, if you're the copyright owner of a song and someone, whether it be the original writer or someone else, does something too close to that song, you're going to sue them for copyright.